Good morning. Thank you for joining Mayor Brown's Global Financial Markets teleconference series. Today's call is entitled CFPB Update, New Developments and Emerging Themes. My name is Ori Lev, and I'm a partner in Mayor Brown's Washington, D.C. office and a member of our Financial Services Regulatory and Enforcement practice. I represent financial institutions and other companies in government enforcement matters, internal investigations and litigation, and provide regulatory advice and counsel on federal consumer financial and economic sanctions law. First, a couple of housekeeping items. As regular listeners will know, this call is being recorded. We will be mailing an audio link to all participants should you wish to listen to the teleconference again or forward it to your colleagues. In addition, the recording will also be available as a podcast on your preferred podcast platform. Since we will not have a Q&A session, please send your questions regarding today's topic by email to gfm@mayorbrown.com and we'll respond promptly. This is the same email address on your invitation email. Joining me today are Mayor Brown Associates Brian Stief and Christa Bieker. Brian is a senior associate in Mayor Brown's Washington, D.C. office and also a member of our Financial Services and Regulatory Enforcement group. Brian represents companies in the mortgage lending, mortgage servicing, and consumer finance industries and federal and state regulatory compliance matters and defends clients subject to government investigations and enforcement proceedings. Christa is an associate in Mayor Brown's Washington, D.C. office and also a member of our Financial Services Regulatory and Enforcement group. Christa defends companies in connections with government investigations and enforcement actions related to the mortgage and consumer credit industry. She also counsels clients on compliance with state and federal consumer finance laws. With that, I'm going to turn it over to Brian, who is going to start today's presentation for us.
Thanks, Ori. One of the most significant trends coming out of the CFPB since the 2020 presidential election is the Bureau's efforts to push the envelope on the scope and uses of its statutory authorities. These efforts started gaining additional steam with the confirmation of Director Chopra last year and have continued through this year with several significant developments. One of the first developments was the CFPB's headline-grabbing use of its market monitoring authority late last year. Under Section 1022C of the Dodd-Frank Act, the Bureau can require covered entities to provide information on topics such as their organization or activities. Historically, the Bureau has used this authority without making public announcements and for the purpose of gathering information for reports, studies, or rulemakings. But last October, the CFPB announced the issuance of 1022C orders to 6 tech companies that operate payment systems. The Bureau's announcement named the companies and included an example order with specific information requests. 2 months later, the Bureau announced the issuance of similar orders to 5 buy now, pay later companies, again naming the companies and providing an example order. While it's unclear how the Bureau will ultimately use the information it receives, the manner in which the Bureau announced the orders is a departure from past practice and may suggest a more aggressive approach. This raises the possibility that the Bureau could rely on information as the basis for supervisory or enforcement actions, a tactic that does not appear to be consistent with the statutory purpose of the authority. The next development occurred this past March when the Bureau unveiled an update to its supervisory procedures that expands the definition of unfairness under the Dodd-Frank Act to include discriminatory conduct. As the primary enforcer of the Equal Credit Opportunity Act, which prohibits discrimination by lenders, the CFPB already wields a powerful tool to combat discrimination. However, ECOA only applies to extensions of credit. Acknowledging this limitation, the CFPB announced that discrimination may meet the criteria for unfairness under the Dodd-Frank Act's prohibition against unfair, deceptive, or abusive acts or practices, or UDAPs. Importantly, that prohibition applies to products and services beyond the extension of credit. Specifically, the Bureau announced that it updated the UDAP section of its examination manual to include a review for discriminatory conduct. The CFPB also stated that it will look for discrimination across activities over which it has supervisory authority, including advertising, pricing, and servicing. Notably, the updated examination procedures do not reference the specific prohibited bases that examiners should consider during a UDAP review of potential discriminatory conduct. As a result, It is unclear whether such a review will consider all the prohibited bases under ECOA, some narrower subset, or perhaps some other undefined demographic. The Bureau's examination manual does not directly or formally impose any independent legal obligations on supervised entities. It does, however, reflect the Bureau's supervisory expectations and carry wide-ranging and real-world implications for companies subject to CFPB supervision. It is also worth noting that the Bureau could rely on this expanded definition of unfairness in future enforcement actions. Next, in April, the CFPB announced that it will begin using a long-dormant statutory authority to examine certain non-bank entities. In 2013, the Bureau issued a procedural rule implementing its statutory authority under Section 1024A1C of the Dodd-Frank Act to supervise non-bank entities offering consumer financial products or services that the Bureau reasonably determines are engaging in conduct that poses risks to customers. While the 2013 rule did not define risk, the ambiguity did not create significant issues because the CFPB did not utilize the rule. However, this recent announcement suggests that the Bureau plans to use this vague and potentially broad authority to expand its supervisory reach. A primary target may be fintech companies, which the Bureau specifically called out in its press release. The Bureau also issued an amendment to the 2013 procedural rule. Under the amendment, the CFPB director's final decision on whether a non-bank should be subject to the Bureau's supervisory authority may be made public on the Bureau's website. To avoid CFPB supervision under this rule, non-bank entities should continue focusing on maintaining robust compliance programs. It's also worth noting that the rule and statute have never been tested, and as a result, we may see challenges to the CFPB's use of this authority. In addition to pushing the envelope on its own authority, in May, the CFPB issued an interpretive rule that describes and reaffirms authorities available to state agencies to bring actions under federal law. Specifically, the rule describes how states can enforce the CFPA, including the provision making it unlawful for covered persons or service providers to violate any provision of federal consumer financial protection laws. The rule also notes that states may pursue claims against a broader array of companies and individuals than the CFPB itself, because certain restrictions in the CFPA technically apply only to the Bureau. Finally, the rule states that CFPB enforcement actions do not preclude state actions. While the interpretive rule mostly reaffirms existing law, it is worth noting that through this action, the CFPB is encouraging state enforcement as another avenue through which market participants can be pressured. And then finally, the Bureau's most recent action to push its statutory boundaries occurred in June when it released a request for information about relationship banking and consumers' ability to obtain information from certain financial institutions. Section 1034C of the Dodd-Frank Act requires certain financial institutions to comply with a consumer's request for certain information concerning a consumer financial protection product or service that the consumer obtained from the institution. The CFPB has never publicly interpreted the provision and has rarely referenced it in Bureau actions. According to the CFPB, the RFI is intended to bring a, quote, sharper focus on more relationship-based banking. While a consumer's ability to obtain information from certain financial institutions under Section 1034C seems relatively limited, the RFI suggests that the CFPB may be poised to use it as the basis to regulate how financial institutions engage with consumers. Financial institutions should consider carefully reviewing the RFI to understand the CFPB's position regarding relationship banking and identify areas where their consumer experience can be enhanced. This will help them stay ahead of the Bureau's ever-expanding supervisory expectations. And with that, I will turn it back over to Ori to talk about the Bureau's recent focus on fees.
Thanks, Brian. I'm going to talk about one of the trends that we've been seeing, and as Brian alluded to, that is a focus on fees in many different contexts. And since the last CFPB update call we did, the CFPB has taken several actions related to fees. First, the agency extended the comment period in response to its request for information regarding what it calls junk fees. That RFI was issued in late January, and comments were originally due at the end of March, but towards the end of that month, the CFPB announced that it had received over 25,000 comments and that it was extending the comment period. In making the announcement, the Bureau indicated it was seeking comments on fees in 4 different contexts. Fees for things that people believed were already covered by the baseline price of a product or service, unexpected fees for a product or service, fees that seemed too high for the purported service, and that sort of pricing of fees seems to be a theme throughout the fee issues, and comments on fees where it was unclear why a fee was charged. It's a little odd because the Bureau only extended the comment period by 11 days, which is not very long, which suggests either they knew of a submitter who was seeking some more time, or that this was simply a news-making excuse to further highlight this initiative. A few months later, in March, the CFPB issued a report regarding credit card late fees, and the report noted that consumers were charged $12 billion in such fees in 2020, and that many major credit card issuers charge the maximum late fee allowed under safe harbor provisions of Regulation Z. As with a number of CFPB reports, this one presaged further action by the Bureau, and a few months after the report was released, the CFPB issued an advance notice of proposed rulemaking regarding credit card late fees. The background to this is that under the Card Act from 2009, credit card issuers can only charge fees that are, quote, reasonable and proportional to the violation of a cardholder agreement. But the Federal Reserve, which had rulemaking authority for the Card Act before the Bureau was established, the Fed had issued a rule providing a safe harbor for fees that don't exceed $30 in today's dollars for the first late payment or $41 for subsequent late payment. The ANPR appears targeted at revisiting the safe harbor and either lowering the fee amounts that benefit from a safe harbor or potentially eliminating the safe harbor altogether and leaving it to companies to determine what kind of fee, in particular credit card late fee, would be reasonable and proportional to the harm. The CFPB also took action to highlight non-sufficient funds, or NSF fees. It issued a blog post focusing on the 25 banks that had reported the most NSF fee revenue in 2021, and it identified 13 of those banks that have publicly announced the elimination of NSF fees, as well as 12 of those banks that have not announced the elimination of those fees. This is a clear use of the agency's bully pulpit to try to drive marketplace conduct short of regulation. Though the blog post also indicates that NSF fees average $34 each, even as any marginal cost to the institution to return a payment is likely exceedingly low. And it goes on to say the Bureau is closely scrutinizing whether and when charging these fees may be unlawful. Again, this is a reference to this notion of the price at which fees are set, and are they, quote, too high for the purported service, one of the factors that the junk fee RFI sought comment on. And finally, with regard to fees, in late June, the Bureau issued an advisory opinion setting forth the agency's interpretation of a Fair Debt Collection Practices Act provision that relates to fees. And that provision of law prohibits the collection of any amount unless such amount is expressly authorized by the agreement creating the debt or permitted by law. And the CFPB's advisory opinion first explains why fees in general are covered by this provision, why they're considered any amount. But more interestingly and importantly, goes on to answer the question about what are referred to as convenience fees, or the Bureau refers to as pay-to-pay fees, that is, fees that a consumer charges to a consumer to make a phone payment or an online payment. And the question that the advisory opinion answers is, what if state law is silent about those fees? Does that mean that they're permitted by law because they're not prohibited? Or does that mean that they're not permitted by law because no law expressly authorizes them? And the Bureau takes the latter position and states that a fee is permitted by law for purposes of the FDCPA only if there's a law that expressly authorizes the fee. So if the debt agreement is silent on such a fee and state law is silent on such a fee, then the Bureau's view is that charging that kind of convenience fee would be prohibited by the FDCPA. While this is an advisory opinion and not a binding rule, courts are likely to give it some deference. And so that is the latest, but almost certainly not the last example of some of the actions the CFPB has been taking to rein in the charging of fees in connection with consumer financial products and services. And I'm going to turn it over to Christa now to talk about one of the other themes that has emerged over the past 6 months to a year. Christa?
Thanks. So in addition to a focus on fees, over the last several months, the CFPB has been active in the consumer reporting space. So last month, the CFPB released a blog post discussing consumer reporting in the Buy Now, Pay Later space. As you may know, Buy Now, Pay Later, or BNPL, is typically a short-term, no-interest consumer credit product. The CFPB's blog recognized the fact that many BNPL companies currently do not furnish information about consumers to consumer reporting agencies. According to the Bureau, there are a couple of issues with this. So first, consumers who pay on time may not benefit from the impact of those timely payments on their credit scores and credit reports. And then second, the lack of reporting may make it more difficult for lenders to understand how much debt prospective borrowers are carrying. So the CFPB emphasized that it would like to see the industry adopt standardized furnishing practices for Buy Now, Pay Later. It also stated that BNPL companies that furnish data should furnish both positive and negative payment data. Now, this is interesting because the CFPB has often seemed focused on the importance of not reporting inaccurate negative data, understandably because it might harm consumers, but they've seemed less focused on the importance of reporting accurate negative data. But here we see the CFPB affirmatively stating that BNPL companies that furnish data should furnish both positive and negative payment data. Next, the CFPB recently filed 2 amicus briefs in cases involving FCRA claims that are pending before the 2nd and 11th Circuits, respectively. The FCRA requires consumer reporting agencies to follow, quote, reasonable procedures to assure maximum possible accuracy of reported information. And it requires furnishers to investigate the accuracy of information they furnish when that information is disputed by a consumer. But some entities have argued in litigation that these requirements don't actually apply when the accuracy of the information is a legal question rather than a factual question. And as an example of the difference between a legal and factual question, consider a vehicle lease that gives the consumer an option to purchase the vehicle at the end of the lease for the residual payment amount. So in one case in which the CFPB filed an amicus brief, the consumer reporting agency argued that whether the consumer owed a balloon payment at the end of a vehicle lease to purchase the vehicle was a legal question and not a factual question. So in its brief, the CFPB argued that FCRA does not exempt consumer reporting agencies or furnishers from FCRA requirements when the accuracy turns on legal questions regarding the underlying reported information. And the Bureau also made the point that the distinction between legal and factual is kind of unworkable because many, if not all, inaccuracies in consumer reports could be characterized as legal. Next, earlier this month, the CFPB issued an interpretive rule addressing the permissible purpose provisions of the FCRA. The FCRA identifies an exclusive list of permissible purposes for which consumer reporting agencies may provide consumer reports. The list of permissible purposes includes providing a report in accordance with the written instructions of the consumer to whom the report relates and for purposes relating to credit, among other purposes. The FCRA also requires consumer reporting agencies to maintain reasonable procedures designed to limit the furnishing of consumer reports to those permissible purposes. The advisory opinion that the Bureau issued emphasizes that the permissible purposes are consumer-specific, that is, they apply only to the consumer who is the subject of the user's request. So in particular, the CFPB explained that a CRA violates the permissible purpose provision if it provides consumer reports on multiple people, such as people with the same name, in response to a request where the user only has a permissible purpose to obtain a report on a single individual. The opinion also states that poor matching procedures, which it says includes name-only matching, may lead to violations of the permissible purpose provisions. Name-only matching means that a CRA reports information as belonging to an individual, based only on the fact that the name associated with the information matches the name of the consumer who is the subject of the report, without also relying on other identifiers like a social security number or a date of birth to confirm the match. Now that's interesting because the CFPB has previously stated that insufficient matching procedures like name-only matching can lead to a violation of the accuracy requirement. That is the requirement that the Consumer Reporting Agency follow reasonable procedures to assure maximum possible accuracy of reported information. Here, the CFPB is going further in stating that insufficient matching procedures like name-only matching can also be a violation of the permissible purpose requirements, because they could cause a consumer report to include information on an individual for whom the user of the report doesn't have a permissible purpose. The final item I'll discuss is the interpretive rule that the CFPB issued in June on the scope of FCRA's preemption provisions. The FCRA provides that only state laws that are inconsistent with the FCRA are preempted, and then only to the extent of the inconsistency. FCRA also lists specific categories of state laws that are preempted. And the CFPB's rule takes a narrow reading of these preemption provisions and seems to be designed to encourage and support state efforts to create requirements relating to consumer reporting. So the CFPB lists certain types of state laws that wouldn't be preempted by the FCRA in its view, including prohibiting consumer reporting agencies from including information about, say, medical debt, evictions, or rental arrears in a consumer report. Also prohibiting furnishers from furnishing that type of information. And it remains to be seen whether the Bureau's statement will encourage states to enact the types of restrictions that the Bureau has mentioned, or if the statement will have an impact in any litigation related to FCRA preemption. But it is clear from all of this activity that the Chopra-led CFPB cares about consumer reporting, and it's paying attention to a pretty wide variety of consumer reporting activities. So entities that are subject to FCRA requirements should expect additional scrutiny. Next, I'll turn it over to Brian, who will describe some trends in CFPB enforcement activity.
Thanks, Christa. Overall, we continue to see a relatively low amount of public enforcement activity from the CFPB compared to our expectations for this administration. This may be the result of new leadership settling in, or the fact that many of the current actions are not ripe for public announcements. But regardless of the reason, based on the CFPB's recent surge in hiring and the range of priorities announced by CFPB leadership over the past year, it's safe to assume we will see more investigations and public actions in the near future. Of the handful of public enforcement actions we have seen in recent months, many are consistent with priorities set forth by Director Chopra in recent speeches and other public statements. I'll briefly touch on three of these priorities. The first is the targeting of repeat offenders. In speeches and congressional testimony, Director Chopra has discussed his intention to focus enforcement efforts on so-called repeat offenders. Based on his comments, this would include two types of companies or individuals. The first is those who violate a formal court or agency order resulting from prior violations, and the second are those who commit multiple violations of law across different business lines. The Bureau's focus on this priority has been demonstrated by three recent enforcement actions. In the first action, the Bureau filed a complaint against a national consumer reporting agency that alleged, among other things, violations of a 2017 consent order the CRA entered into with the Bureau. The CFPB highlighted these order violations in its press release and included the 2017 order as an appendix to the complaint. Just over a week later, the Bureau filed a separate lawsuit with the New York AG against a non-bank remittance transfer provider for violations of the EFTA, Regulation E, and the CFPA. While the Bureau's complaint does not cite prior violations by the defendant, the CFPB labeled the entity a, quote, repeat offender in its press release, citing prior actions brought by the FTC and the DOJ. This is notable as it suggests that the CFPB will focus on any past violations of law, whether or not they involved a CFPB action. Finally, and most recently, on July 12th, the CFPB filed a lawsuit against a payday lender alleging a number of UDAP violations in connection with the concealment of certain loan repayment plans available to the consumers. Although not serving as a basis for a legal claim, the complaint and the Bureau's press release both cited a 2014 consent order the defendant entered into with the CFPB for problematic debt collection activity. The press release specifically labeled the defendant as a repeat offender, further emphasizing the Bureau's focus on this issue. The second priority I want to highlight is the targeting of individuals. We have seen a number of statements from Director Chopra noting a focus on holding individuals accountable. The Director's comments on this topic are noteworthy because while the CFPB has held individuals accountable for corporate violations in the past, the actions have generally involved smaller companies and owner-operators. The Director's speeches have taken aim at larger companies, noting that size should not impact the targeting of individuals. 3 of the recent enforcement actions we've seen, filed since February, included individual defendants. 2 of those actions involved allegations against owner-operators of relatively small companies. These actions are consistent with past Bureau practices of pursuing claims against such individuals. The third action, however, is arguably much more significant. In that action, the Bureau filed a lawsuit against a national consumer reporting agency and a former senior executive of that company. In addition to naming the executive as a defendant in the action, the CFPB included the executive in its press release and provided details regarding his responsibilities and compensation. While the executive had left the CRA prior to the filing of the complaint, the action is still one of the most significant instances of the CFPB targeting an individual defendant. And then finally, the last priority I want to discuss is the Bureau's focus on non-monetary structural remedies. Specifically, the Director has suggested that government regulators should more frequently use the more drastic tools in their arsenal to punish entities and individuals. For example, he's mentioned lifetime occupational bans and the forced dismissal of senior management and board directors. 2 of the recent enforcement actions filed since February have included industry bans for individuals. While these bans are not inconsistent with the Bureau's past practices, when taken together with the Director's statements, they suggest the Bureau will continue to pursue non-monetary remedies, specifically those that hold individuals accountable for alleged violations. And now I will turn it back to Christa to talk about some trends in Bureau supervision.
Thanks, Brian. The Bureau released its spring 2022 edition of Supervisory Highlights in May. This issue covers exams completed between July and December 2021, and notably it's the first edition that covers some exams completed during Director Chopra's tenure. It identifies a violation in a number of areas, but although the Bureau has recently emphasized fair lending and anti-discrimination concerns, and the report itself states that an important goal of the Bureau's supervisory work is to foster financial inclusion and racial equity, this edition doesn't include any fair lending-related findings. It also doesn't include any mortgage servicing-related findings, despite the Bureau's recent focus on servicing for borrowers impacted by COVID. I'll walk through some of the issue's findings. First, this edition discusses several violations of the UDOT prohibition related to auto loan servicing. According to the report, some servicers engaged in deceptive acts or practices in connection with deferrals offered to consumers. The deferrals were likely to increase consumers' final payment amounts, and so the servicers sent consumers a notice, and it stated that their final payment, quote, may be larger, while in fact, consumers' payments often dramatically increased. And the CFPB called the servicer's statements that the final payment may be larger, imprecise and conditional, and likely to mislead consumers about their final loan payment amount. So although this finding relates to auto loan servicers, servicers of other consumer credit products like mortgage servicers should take note when drafting consumer-facing letters that describe loss mitigation options. In addition, CFPB examiners identified wrongful repossessions at auto servicers. According to the Bureau, servicers engaged in unfair acts or practices when they repossessed vehicles after consumers took an action that the servicers said would prevent the repossession. Along these lines, the CFPB has seen concern about auto repossession, and earlier this year, they released a bulletin that focused on mitigating the harm of auto repossession. And as I discussed earlier, in the last several months, the CFPB has been focused on consumer reporting and compliance with the FCRA. And consistent with that focus, this edition of Supervisory Highlights identified a number of violations of the FCRA. Quite a few of these findings related to disputed information. So, for example, the report states that in some cases, consumer reporting agencies just deleted disputed information rather than actually resolving the disputes and potentially replacing the inaccurate derogatory information with accurate positive information. Examiners also determined that some consumer reporting agencies failed to provide a notice of the dispute to the person that provided the disputed information within the 5 days that Bieker requires them to provide that notice. The report further states that some consumer reporting agencies failed to provide a written notice of the results of the dispute within 5 days after the completion of their reinvestigation as required by FCRA. And in some cases, the CFPB said the notices that the CRAs did send incorrectly described the result of the reinvestigation. So this edition of Supervisory Highlights contains a number of other findings, and we summarize many of those additional findings on our blog, the Mayer Brown Consumer Financial Services Review. And so, Ori, now I'll turn it back to you to discuss some additional developments at the Bureau.
Thanks, Christa. The last thing we wanted to touch on was the slow dismantling of the CFPB's innovation programs. And these are the programs that I think could have been one of Kathleen Kraninger's enduring legacies, but seem destined to not be. For the first 7 years of the Bureau's existence, it had a program called Project Catalyst that was intended to promote innovation, but was largely ineffectual, and the Bureau had issued one no-action letter in that time period. Kathleen Kraninger, when she became director, reinvigorated the innovation program. She rebranded Project Catalyst as the Office of Innovation. The office actually began issuing no-action letters. They issued 6 such letters during her tenure. And they also launched a compliance assistance sandbox, which was a program pursuant to which companies can get approvals that provide assurance that certain aspects of a product or service are compliant with specified legal provisions. Essentially, approvals provided a safe harbor from liability under certain laws where the applicability of those laws was unclear. And finally, the Bureau also adopted an advisory opinion program. It now seems that the no-action letter and compliance assistance sandbox policies are unlikely to be used during Director Rohit Chopra's tenure. On May 24th, the CFPB announced it was rebranding the Office of Innovation and is going to call it the Office of Competition and Innovation, consistent with Director Chopra's focus on competition. And in rebranding the office, the Bureau also took several rhetorical swipes at the no-action letter and sandbox policies. It described those policies as, quote, conferring special regulatory treatment on individual companies. And then it went on to say that after a review of the programs, quote, the agency concludes that the initiatives proved to be ineffective and that some firms participating in these programs made public statements indicating that the Bureau had conferred benefits upon them that the Bureau expressly did not. And then the announcement goes on to describe the Office of Competition as one that's intended to support a broader initiative to analyze obstacles to open markets, end quote. But doesn't sound like that office is going to do anything in particular or specific in the same way that the no-action letter and sandbox approvals were specific programs. 2 weeks after that announcement, the CFPB issued an order rescinding one of its no-action letters. This was done at the letter's recipient's request because they were changing the AI-driven underwriting and pricing model that was the subject of the no-action letter, and they didn't want to wait for the CFPB's review of those changes. But it's hard not to see the company's request to terminate its no-action letter as related to the CFPB's apparent hostility to what it now views as special regulatory treatment. And a couple weeks after that, the CFPB rescinded one of its compliance assistance sandbox approvals, also ostensibly at the request of the company that had that approval, though the CFPB noted that the Bureau had told the company that the CFPB was considering terminating that approval because of certain public statements the company had made allegedly suggesting that the CFPB endorsed its product when the company said it had an approval from the CFPB. So while these programs still exist on paper, they haven't been technically rescinded. It appears unlikely that the Bureau is going to grant any new no-action letters or sandbox approvals since it views them derogatorily as special regulatory treatment. I think that's unfortunate. These are programs that allowed companies to come to market with innovative products without the risk of an enforcement action, and also provided the CFPB with important information about how new and innovative product operated. That is, there was a two-way street here where the Bureau, as a condition of providing these assurances, was getting information from companies, and the Bureau presumably will not be getting that information anymore, and this will not be, at least for the short-term, part of Kathy Kraninger's legacy. That's the end of the substance of our program today. Thank you to our audience for tuning in. A few brief reminders. You will receive an email with a link to the recording of today's call, and the recording will also be available as a podcast on your preferred podcast platform. Lastly, as mentioned before, if you have any questions related to today's content, please email them to gfm@mayorbrown.com. Thank you again for your participation. You may all now disconnect.